Good morning. For the purpose of criminal practice lawyers as well as the exam aspirant to become judge, district judge and district municipal, first I will share with this judgment, then I will go to root of the act. This case pertaining to food adulteration case. You see AR 2023 Supreme Court 2123. Therein, a vendor of pan masala was charged for offence under section 7, 14, 19, 20A of the Prevention of Food Adulteration Act and Rule 12A of the Food Adulteration Rules. The lower court convicted and district appeal dismissed, CRP before the High Court also dismissed. But the Supreme Court says, in view of section 19(2)A, if the manufacturer of that particular goods gives some warranty declaration on the manufacturing cover itself, that is sufficient for protection of vendor who sells it. So they would have impleaded the manufacturer as an accused, not this poor vendor. This is what they say, and they have discussed about the manufacturer, distributors and dealers to give warranty. Then defenses which may not be allowed in prosecution under this act. Then they say vendor shall not be deemed to have committed an offence pertaining to the sale of any adulterated, misbranded article of food if he proves that he purchased the article of food in a case where license is prescribed for sale thereof from a duly licensed manufacturer, distributor or dealer. Then that article of food while in his possession was properly stored and that he sold it in the same state as he purchased it. Or then 3, any person by whom a warranty as is referred in section 14 is alleged to have been given shall be entitled to appear at the hearing and give evidence. These all are the things. So, in any other case, from any manufacturer, distributor, dealer with a written warranty in the prescribed form, then the vendor, the retail vendor should not be prosecuted. Now, this is what the judgment. For all your kind information, this Food Adulteration Act is now being repealed and brought as Food Safety and Standards Act 2006. Now but you cannot ignore this act for 1954 Act for this purpose, because multi-number of cases, appeals, revisions are still pending, which were underwent trial under Prevention of Food Adulteration Act. Therefore, this is most important. See, there are 2 categories of Food Adulteration Act offence. One is adulteration, another was misbranded. Then there are so many other aspects which you have to go through the act, but this is most important. So, you have also to undergo this 2006 Food Adulteration Act, Safety Act as well as Food Adulteration Act. Now it is very crystal clear that the small vendors shall not be prosecuted for misbranded or adulterated food. So how to prosecute food adulteration cases is somewhat different procedures. They have to purchase it, then they have to send it to the laboratory within a stipulated time and intimate the to keep one seal intact and inform the accused that he can send the another sample by requesting the honorable court within stipulated time to forward it to Central Food Laboratory. These all are the protections are given. The time-bound case, just like Negotiable Instrument Act. Therefore, kindly strictly follow this act. Definitely there shall be a case under this. What is misbrand? What is then question of malice, with intent to uh, commit crime. All these things are there time and again. You see, even the rules, time to time rules are being issued under Food Adulteration Act, stating that this product shall not be used before after 6 months. Then they say it should be, they say they must say some specific date also. Time to time they will vary, and even that rules amendment reaches the manufacturers or other vendors, and there may be a prosecution, and courts, high courts have come to rescue such accused for absence of malice or intention to disobey the declaration of misbranded. All these things are there. Kindly take note of these cases. I think I completed one. Best wishes.